Okay, in this one, write the motion dated 14th October 2025, brought pursuant to the provisions of Article 50 and 159 of the Constitution, Section 1A, 1B, and 3A of the Civil Procedure Act, Rules 8, 9 of the Advocates Practice Rules, paragraph 95 and 96 of the Law Society of Kenya Code of Standard of Professional Practice and Ethical Conduct. The defendants sought the following orders. Number one was spent. Two was pending the hearing and determination of this application inter partes. The Honorable Court be pleased to issue interim orders barring Advocate Japheth Ochutsi Munyendo, P105 15 to 57 of 2018 from appearing, acting, or participating in any capacity in civil suit number 37 of 2021, either for or on behalf of his father, the plaintiff, Johnston Munyendo Ochutsi. 3. Upon inter partes hearing, the court be pleased to confirm that the said interim orders and formally bar the said advocate from representing the plaintiff on account of conflict of interest. 4. That the plaintiff be directed to continue to be represented by the advocate on record, Mr. Alex Mbeka, or any other duly appointed advocate who is not conflicted. 5. The Honorable Court do issue any other or further orders that may be necessary to uphold the integrity of the judicial process. 6. Cost of the application being cost. Okay, I'll just read the determination and I'll put it on the platform. Now, I consider the application and the reply thereto. I also consider the rival submissions by counsels for both parties and the various authorities cited therein. The issue for determination in this application appears to be only one, to wit, whether the court should bar Mr. Japheth Ochutsi Munyendo, advocate, from acting for the plaintiff in this case. From the onset, I wish to appreciate the fact that this is a peculiar case. The reason being that this is a case where the advocate is the biological son of the plaintiff. I note that the circumstances envisaged in the provisions of law and the authorities cited above do not exactly capture a scenario such as this. However, I shall derive my guidance from the case cited by the defendant's counsel, to wit Francis Mugo and 22 others, versus James Brace Mude and 3 others, in which Justice Daniel Musinga rendered himself thus, and I quote, an advocate has a duty to clients, a duty to his opponents, a duty to the court, a duty to himself, and a duty to the state. As an officer of court, he owes allegiance to the cause that is higher than serving the interest of his client, and that is to the cause of justice and truth. Inasmuch as I would agree with counsel for the plaintiff that both the Advocates Practice Rules and the Law Society of Kenya Code of Standard of Professional Practice and Ethical Conduct do not technically restrict lawyers from representing family members and are not very specific as to the circumstances under which an advocate may be barred from representing a family member in legal proceedings. The dilemma the court has is just how Mr. Ochutsi will balance between being the son of the plaintiff and his advocate at the same time. Inasmuch as the courts have the duty to interpret and uphold the law to meet the ends of justice, they certainly do not operate in a vacuum. Courts have to operate without being oblivious of what happens in the real world. By this I mean, what guarantee is there that Mr. Ochutsi will conduct his father's case without putting any emotions in it? In my view, it is unrealistic to imagine that he will treat this case like any other case, detach himself completely from the relationship he has with the plaintiff, and treat him like any other of his clients. Be that as it may, that Mr. Mbeka has every right to choose an advocate of his choice to hold his brief. He does not have to choose Mr. Ochutsi only. I'm sure Mr. Mbeka knows many advocates he can instruct who are just as competent as Mr. Ochutsi. Therefore, in my view, in the interest of justice and to relieve Mr. Ochutsi of the heavy burden of representing his father and the emotional stress that may arise therefrom, with tremendous respect, humility, and respect, putting it the Kenya's way, so to say, I will ask Mr. Ochutsi to step aside and let Mr. Mbeka or any other counsel instructed by him to conduct the case. This, in my view, is in the best interest of everybody, especially Mr. Ochutsi. And before I pen off, I wish to urge counsels for both parties to treat each other with courtesy and respect in the course of these proceedings until the determination of this case. By this, I mean refraining from such acts as sending each other emojis which would appear to mock a fellow colleague. This is rather discourteous, to say the least. In the end, I will allow the application, and the case should proceed for hearing as scheduled. Mr. Mbeka, you just proceed. Let's leave Mr. Ochutsi outside.
It's okay.
Yeah.
Maybe we can just grant his bail to appeal.
Okay. Yeah, good. So, plaintiffs granted leave to appeal the ruling dated 1st of December 2025. Mr. Rene.
Yes, Your Honor.
Mr. Mbeka is here. He has one witness. So he says, I don't know if you are ready.
I'm ready, Your Honor.
You are ready?
Yes, I'll also be calling 4 witnesses who will be very, very brief.
Okay. Because I was even mentioning to Mr. Mbeka here that we are on transfer, but if you are ready, we'll proceed. There's no problem. We'll proceed. Mr. Mbeka says there would be a site visit, meaning I have to put it somewhere in the second week of December. So, Mr. Mbeka, let me mention the other cases and then we start with them. I'm not sure if
maybe if I can just bring to the attention also counsel. On my notes, I'm ready with the plaintiff, but I don't have my surveyor today in court. If the court allows, we can proceed partially, and then I'll seek an adjournment to call the surveyor. It is important that I call on my witnesses before Mr. Rene receives witnesses.
Okay.
And so, taking into account that the court is going on transfer, I don't know whether we proceed partially before you, then the matter again to proceed before another magistrate.
I don't know. Mr. Rene, what's your view on this? Because
Your Honor, I have a different view. The plaintiff normally has a right to begin under Order 18. The court can direct that even a defendant can begin.
Yes.
You know what I'm saying? Whereas the plaintiff has the right to begin under Order 18 and 17 of the rules, the court can also direct that the defendant has a right to begin. So therefore, in my view, nothing precludes the defendants from giving their testimonies in full because they're all ready. And if the plaintiff will be calling their surveyor, who is an expert witness, he can come last. So that we save the court's time, yes. So we can take all witnesses who are available today.
I don't know. I would think it's always just good to start with the plaintiff for the purposes of the record anyway. Mr. Mbeka.
I've heard what counsel has indicated, but it's important that we be granted the opportunity to present our case first, we close our case, then the defense can proceed with the witness. Because
when can you have a surveyor? Because my thinking was we can start today with the witness. Friday I don't have any cases on Friday. Then we can try and conclude it on Friday this week. Will that be it?
Friday I'll be engaged. I have I'll be in Butere, ENC number E033 of 2024.
How long will you be in Butere?
It's a land matter, it's also mediation. There are 2 files, one in Butere and another one in Kakamega. Kakamega, the grant was revoked. It's a big family of around 4 wives, so I don't know how long it's going to take.
Okay. The next Friday? so that we do the surveyor and Mr. Rene's clients. We can do this one witness today.
The following training is on 12. Maybe we can try on 10.
10 is
it's on a Wednesday.
Wednesday.
Do you do civil matters on Wednesday?
No, I do criminal. I don't know.
Then
the reason, it's 12. 12 is a holiday.
Yeah.
The best days normally for me are normally Mondays like today and Fridays. So unless we try, instead of Friday, we try Monday.
Monday or
that Monday just next week.
I don't know how soon on 15th I have my hearing soon.
Yeah, that is 8 is well.
Unless now up to around December 19th.
19th is a Friday.
Yes. I don't know what it is.
Mr. Rene, if we do today and then 19th we do all of you, we do yours, and 19th is okay. I know there are no people. The Fridays are okay with me.
You know very well. Perhaps council will just confirm that he'll be ready, because even me, I have many matters, but I also put aside my matters aside to run to this matter.
Okay, let's agree, Mr. Becker. You will present your witness on Friday the 19th.
Yes.
And Mr. Rene, you'll be ready with yours. So with yours also the same 19th. We do it finish. We have only submissions. Then I do the judgment. If you want us to do the site visit, we agree on 19th so that I make the necessary arrangements. I don't know if Mr. Rene will be available.
I'll be available, Your Honor. That is in order. I can do the hearing, then do the site visit on the same day.
I'll organize for the site visit then. Okay, we agreed. So let me mention the matters. Then we do Mr. Becker's client partially, or we hear the plaintiff.
Yes.
Okay.
We'll get back to you, Mr. Rene.